Rodriguez-Martin versus State.
Yes, Your Honors. Good morning. My name is Dana Mader, and I represent Mr. Rodriguez-Martin. We refer to him as Mr. Rodriguez. And prior to argument, I did want to briefly explain there's a little bit of a procedural oddity here. We're here on the state's appeal of a judgment of acquittal, and Mr. Rodriguez would not have otherwise appealed.
Usually it's the other way around.
It is. And so what happened here was the state filed their notice of appeal. Mr. Rodriguez filed the cross appeal. And then there was an order from this court instructing us to switch roles, and they switched the case style.
To tell you the truth, I don't know why that happened, but
Just because we do something doesn't mean we're right.
I guess it's because we're just so used to it being the other way around. I don't know.
I understand. I just wanted to let you know so there was no confusion when I started arguing the judgment of acquittal, or why we would come to this court today for something seemingly essentially not appealable, because Mr. Rodriguez was successful below. So the only verdict here was his misdemeanor, which he's already served.
So what you're saying is you weren't all het to reverse the misdemeanor until the state appeal.
Yes, Your Honor, that's correct. So with that, I'll begin. I will discuss the judgment of acquittal first. We are asking this court to affirm. And first, I want to point out that we're in the 2019 statute, and the 2019 statute is very clear, and the case law is very clear about some fundamental differences that arose in this case. The two issues that we're here about today are the idea of penetration versus union with when we are discussing sexual battery. And we're under statute 794.011 sub 1H regarding sex bat. And the definition in that does say that it must be, to be found guilty of that statute, it must include penetration with an other object. The only time that union with works in that statute is when it refers to a sexual organ. So we're here discussing penetration, and I'm sorry, this is a little uncomfortable to talk about on live streaming here in front of you, but I will do my best. We are here discussing penetration with an object, which is allegedly Mr. Rodriguez's fingers with a minor child.
So the bottom line is, because the testimony was in union with, and the statute requires penetration, there's no way the jury could have come back with the verdict that it came to. Is that what you're saying?
That's exactly it, Your Honor. And this court itself has defined that in great detail in both cases, Richards, 738 Southern 2nd 415, and Palazzo, Palazzo, 754 Southern 2nd 731. Both of those discuss in detail and even include the dictionary definition of vagina, which is not vulva, it is not labia, it is a vaginal canal. And so when we're talking about a life in prison without parole, we're discussing millimeters, and those millimeters are important. And here, when we went to the hearing on the judgment of acquittal, the court bantered back and forth, of course, with both counsel about this very issue. Reread the calls, reread the testimony, listened to both attorneys, and said, well, there was not specifically any testimony about penetration that was never clarified or asked about. So the only two issues, or the only two times, when there was testimony about penetration was when the minor child said, in my vagina, without further clarification, and then on my vagina, and then yeah, when somebody asked her to clarify something.
Why would that be not to go to the jury?
It's not because vagina wasn't clarified. And those two cases tell us specifically that children tend to use vagina to mean the entirety of that area down there. And even at one point, Mr. Rodriguez just used the word PP. I apologize.
Was that argument made to the court?
Well, it didn't need to be. The court found that on her own. So when we were in the judgment of acquittal hearing, the judge said, was there any specific testimony to clarification of what vagina meant, and it wasn't there. And, we would argue that the court can recognize the issue. That's her discretion, and she needs to correct things in our courtroom, and she figured it out, and she's right. Admittedly, we didn't raise it in our JOA motion, but we did discuss it at length in that hearing, and that's when the court came to its conclusion. The state does mention it not being in the actual written order, but when the court reads that together with the hearing transcript, it's abundantly clear. And it's worth pointing out that the state is the one who asked for and wrote for the court that proposed order. So with that, we believe that this court can and should affirm the judgment of acquittal, but if the court does not, then we do have two sub-issues on our cross appeal, which became the appeal, that we believe should be addressed by this court should it remand. And if this court does reverse and remand, we do ask that the court allow for the judge to actually determine or decide the motion for new trial. So there was a motion for new trial filed by Mr. Rodriguez along with the judgment of acquittal. That was never heard. It wasn't gotten to because the judgment of acquittal was granted. But should this court reverse and remand?
The original count 5?
I
The
apologize.
original count 5?
Yes, that's correct. For the original count 5. Original, I believe it was the original count 6, count 5 during the trial.
I guess.
Yes, Your Honor. So actually, when we talk about the verdict form, we will be able to talk about that in length. It was raised in the JOA hearing as well, the issue with the jury instructions and the verdict form. And they discussed that in count 6 of the information, the state only charged with penetration, as it should under the statute. But then at trial, things got a little wonky. The jury instructions said union means contact under count 5. So even though the jury instructions that the jury was read and looked at didn't say union with, 2 lines below it, still in count 5, it said union means contact. Then on the verdict form, it actually did have the full error where it says penetration or union with an object.
Wait a second, didn't the defense attorney agree to the verdict form?
He did at the time, yes, but then he raised the error in the judgment of acquittal.
Well, it's kind of late after you agree to something, and say, oh, I didn't mean what I said. I mean, I don't understand what you're trying to get us to believe there.
So it could be, but then it would be fundamental error. So whether you agree that it was preserved.
You're saying, if I'm correct, it's not preserved, but it's fundamental?
Yes, Your Honor.
Because could have convicted him of crime not charged, but there's no motion limited to have the state specify. And the information to begin with was very specific, probably unnecessarily so, but the state chose to be very specific. So the defense didn't raise the motion limited. And you're saying that's still a fundamental error by use of the word or on the verdict form?
I absolutely believe it is because it's a lesser crime. And whenever there's an erroneous instruction that improperly weakens the critical element, and we're talking life in prison without the possibility of
He got
parole.
life on one count, right?
He did not. And he was acquitted.
What did he get on the count he was convicted of?
Misdemeanor, 180 days. I apologize. Misdemeanor,
The
180.
jury came back with a verdict on 1 count, cat, and a lesser included misdemeanor, correct? And then the judge set aside the.
Yes, so it was count 6. Yeah, the lewd and lascivious, that's correct. The jury came back with lewd and lascivious for touching of the breast and the penetration or union with a finger, which was count 5, which was the cat pattern. So we do believe that there's fundamental error there because the in union with that was on the verdict form that the judge orally said at trial to the jury, and that when the jury's verdict was read out loud, we, the jury, found in union with, we believe that that is enough to preserve fundamental error. And the state will say it isn't. The state will say it wasn't relied on, that they only relied on penetration and that they met that burden, but they can't say that because we don't know if 1, 2, or all of the jury relied on union with when they chose that.
Did he make any improper arguments concerning that jury instruction?
They did in the judgment of acquittal hearing, yes. So if your honors agree with me.
Not to the jury.
No, not to the jury.
That was my question.
Well, they did argue in closing, of course, that there was no penetration. But as far as arguing that error, it did not happen during trial. It happened afterward. Yes, that's correct. Yes, I apologize. So yes, after the trial, when there was a judgment of acquittal, hearing, it was argued there. So I would submit to you that that is preservation. But if the court disagrees with me, then the court should find that it's fundamental error. That's in a Florida Supreme Court case, Reed, 837 Southern 2nd, 366, apologize. And that's the one that talks about improperly weakening a critical element. So it should be fundamental error, point blank, to have an improper jury instruction, proper verdict form. But there is a little bit of wiggle room that the state mentioned in their brief, but that wiggle room fails when it improperly weakens the critical element, which this absolutely did, because touching, even in, as it refers to certain other biological areas that are not actually the vaginal canal, that does weaken the critical element of penetration that would require life in prison. And then our other issue, of course, Your Honors, is the controlled calls. There were 2 calls that the minor child's mother made to Mr. Rodriguez, and I apologize. Can you let me know where the time clock is?
Right here.
Oh, okay. Well, please let me know.
You have used 9.5 minutes.
I appreciate that, Your Honor. My apologies.
Yeah, there's one up there too, but it's hard.
Yes. Okay. So the controlled calls, if you do reverse on the JOA, we firmly believe these should not come in. First of all, count 5 would be the only count that you're sending back to the judge, and then of course
show consciousness of guilt, and they look to be inextricably intertwined.
Okay.
With this whole incident.
So-
and as you know, I'm parroting the buzzwords from the cases that would say it's okay for that to come in.
Absolutely. And the state found those same buzzwords, Your Honor. Consciousness of guilt, though, it has to be for that same alleged crime. It has to occur after the crime, and it has to be consciousness of guilt for that actual crime. We don't have that here. In fact, it's almost incomprehensible that someone would think so.
That occurred in a bathtub.
Correct.
And while she never said anything about a touching in a bathtub, this is all about a touching.
Yes, but the court confirmed that the only 6 instances that the minor child discussed, none of them happened in a bathtub, and none of them involved the things that were in the controlled calls. The controlled calls did not talk about touching a vagina or anything of that nature. It talked about touching her butt and then kind of her PP area is what he called it when he was drying her off. And
So I guess that the theory of it coming in was that he in his phone call was creating his own Williams Rule evidence.
was creating his own what? I'm sorry, Judge
Williams
Martin.
Rule evidence, uncharged crime.
Yes, absolutely. And it wasn't, right? The court could have, or excuse me, the state could have, and it didn't.
There
And
was no notice of a Williams Rule based on that.
well, right. No, there was no note. Well, we do argue the Williams Rule in our briefs, and we do say that it didn't. I apologize.
If there was the state had given notice that it was going to introduce Williams Rule evidence vis-a-vis these phone calls.
Right, absolutely. So there was no 4-prong test. There was nothing that met that burden of bringing them in as collateral. They're not inextricably intertwined, excuse me, because not only do they not talk about the same type of charge, they don't talk about the same location, and they don't talk about the same time frame. She was very young when he was bathing her. She said everything happened when she was 9 or 10, and that is what is in the charge as well. The charge has specific dates that are in 2019. So these calls can't come in. They literally do not talk about the same instances at all, not time, not location, and not description. And we think it was error for them to come in. Obviously, that was argued below at length in both the motion in limine and in the judgment of acquittal transcripts. But the inextricably, intertwined, that has a separate burden. And the state brought that up for the first time on appeal. And to be error, they said it had to impact the jury, but we contend that it did. The state relied almost solely on those calls. The minor child's testimony was weak, it was inconsistent. The judge had to question her about telling the truth multiple times. Sometimes she told the truth, sometimes she didn't. And then at one point, the minor child even said she guessed she was just saying it because the prosecutor told her to. And so because of all that, these calls, they were mentioned in the opening, right? If that's not an admission of guilt, I don't know what is. It was mentioned in the closing. It was mentioned all throughout the mother, the sister of Mr. Rodriguez, all throughout her testimony, these calls were very, very, very crucial to the state, and they should not have come in. They don't matter here. They don't have anything to do with this case. And we contend that especially now they don't have anything to do with count 5, because incident 2, she talks about being in the bedroom and being clothed. So that even pushes it further out, because we only have one incident that
So given
should.
the nature of the verdicts in this case, why isn't this harmless error? Because most of the counts he's found not guilty on, he's found guilty on a lesser included offense. And then, of course, the court gave a judgment acquittal on the offense that had the union with and not the penetration. So why in this harmless error? Obviously, the jury wasn't persuaded it was very helpful.
I agree, but then when we come back to the count 5 that the jury did find something persuasive, we're not sure what, because of the faulty verdict form and the faulty instruction that was given by the judge. But because something happened to make them choose that, in an abundance of caution and to be fair to my client and to follow the rule of law, these calls can't come in. They absolutely cannot. And Griffin tells us that, right? 639 Southern 2nd, 966. It's a Florida case, Florida Supreme Court case from 1994. It says when they're necessary to establish the entire context out of which the crime arose, that's when they can be included. That did not happen here. And even...
You did not mention whether you want to reserve rebuttal time.
Oh, I apologize. I got confused with
You're
the
down to 5 minutes.
the procedural issue here. Or excuse me, yes. So I would like to reserve, so if there are no further questions. Thank you.
Good morning, Your Honors, Counsel. May it please the court. My name is Nicole Smith, and I'm appearing on behalf of the state in this matter, who is the cross appellee. I'd actually like to start, unless the court disagrees, I'd actually like to start with the cross appeal in this
Somehow
matter.
that doesn't surprise me.
So in count 5 of the revised information, Mr. Martin was charged with capital sexual battery by digital penetration. A jury deliberated and returned a guilty verdict on this count. And to support this verdict, I'd like to direct this court's attention specifically to the victim's testimony on pages 228 to 230 and page 269 of the trial transcript. On direct, the victim specifically stated, "He touched me in my vagina." She specified that it happened in the bedroom at Mr. Martin's house. And when the prosecutor asked the victim to clarify, "Did he touch you in your vagina?" she responded, "Yes." When asked, "What did he touch you with?" she specified that Mr. Martin, her uncle, used his pointer finger. She testified that he put his finger under my underwear. When the prosecutor again asked for clarification on page 230, "Did he touch the inside of your body?" she responded, "Yeah." When the prosecutor asked her, "How did that make you feel?" the victim responded, "Uncomfortable." And then again, on page 269 of the transcript, during cross-examination, defense counsel stated, quote, "The second time was his hand or finger were in your vagina, right?" To which the victim responded, "Yes." And despite this unequivocal testimony establishing digital penetration, the trial court, in its oral pronouncement, stated on page 177 of the confidential record, the trial court stated, quote, "Based on her description of the second event, not specifically saying penetrated her vagina, that was never asked or clarified. I'm going to grant the judgment of acquittal on count 5, notwithstanding the verdict." Now, Your Honors, we're here today because the trial court did not have the benefit of the trial transcript that this court has. And instead, it relied on its faulty recollection and personal notes from the trial. And I'd like to note that the verdict was returned on October 7th, and this JOA hearing was conducted on the 21st, which was just shy of 2 weeks later.
Let me ask you a question. What is the remedy you believe applies if we were to agree with your argument and reverse on that count? What's the remedy? What happens on remand?
On remand, the trial court should reinstate the jury's verdict,
As opposed to a new trial?
enter judgment, and sentence Mr. Martin in accordance with the jury's verdict. And Your Honor,
What's the sentence that's only possible in this case?
a life sentence. It's a mandatory life sentence. The jury convicted him.
What you're saying, we remand a reinstatement and the court gets the sentence as opposed to us telling them what to do.
Correct.
Okay, thank you.
And it's the state's position that upon de novo review, applying the competent substantial evidence standard, considering the evidence in the light most favorable to the state, this court should find that the trial court erred in granting the judgment of acquittal because the state indeed presented sufficient evidence to support the jury's verdict.
But if we, I suppose it's possible, if we agree with you that the judge should not set that verdict aside for that reason, but we also agree with the defense that the phone call should not come in, we ran for a new trial.
No, Your Honor.
That charge?
No, Your Honor, as Judge Morris pointed out, these calls, yes, they were a part of the state's case, and they were evidence.
The state pretty much hammered on these calls.
They did, because
Yeah.
these calls were
And
clear
so
admissions.
We decide that the calls should not have been used or referred to. We ran for a new trial on the count sex bad count.
Well, Your Honor, it's the state's position that that would not be the appropriate remedy, because during the hearing, there were arguments for a motion for new trial as well as for the JOA. Obviously, the court granted the JOA, but defense counsel made arguments with respect to the weight of the evidence during that motion. And the judge determined that the state failed to present competent substantial evidence and eventually entered a
Correct.
judgment.
And so the court did not have to go to the question of prejudice as a result of the calls.
Well, Your Honor, the court previously reviewed the motion in limine to exclude these calls and determined that specifically, I don't agree with your interpretation of these calls being an outside incident.
Of course, we might feel differently.
Your Honor, the victim's testimony alone constitutes competent substantial evidence. As I just highlighted for the court, it's clear that the victim was very consistent in her testimony. She specifically used the words in and inside, which clearly demonstrates digital penetration, Your Honor. So even without the calls, this victim's testimony alone presented competent substantial evidence to support the jury's verdict finding Mr. Martin guilty of capital sexual battery by digital penetration. So it's the state's position that the state would respectfully ask this court to reverse the trial court's order granting the judgment of acquittal on count 5 and remand with instructions to reinstate the verdict, enter judgment, and sentence Mr. Martin in accordance with the jury's verdict, which would be a mandatory life sentence. And unless the court has any other questions on the cross appeal, I'll move to the first issue raised in the initial brief, which is the controlled calls. It's the state's position that the trial court acted within its discretion in admitting these controlled calls. They were relevant because these calls were placed 4 days before Mr. Martin's arrest for these charges. They specifically discussed sexual allegations the victim made to her mother, who then confronted Mr. Martin on the first call. They also provide context for how the charges arose and describe the events leading up to the charged crimes. Again, he was arrested 4 days after this call. They clearly include admissions and show consciousness of guilt. And I would also like to point out that the second control call was actually Mr. Martin calling his sister back. He called his sister back 6 minutes later after she told him during the first call that the victim told her that he, quote, fondled her and touched her. She told him that she was on the way to pick up her daughter and take her to an appointment to see a doctor. And the call ended, and 6 minutes later, it was Mr. Martin who initiated this call and called her back. And during the call, I'd just like to highlight some of the things that Mr. Martin said during this call. On page 87 of the confidential record, he admitted that he touched his nieces. He used the term pee-pee. I think we can all agree that a pee-pee he's referring to the victim's vagina. He stated on page 89, "What I did was really wrong and I have to pay for that. on page 90, he says, I made a really big mistake and what I did was really wrong. He repeatedly asked for forgiveness. He stated, I'm too aware I can't live with that. He stated, I know what I did and I have to pay for that. And I ask you for forgiveness. He says, sister, I need to be treated by a psychologist and they're automatically going to put me in jail. And I'm willing to do that because I know what I did. And what I did was really wrong and I have to pay for that. And I'd also like to note for this court on page 92, he specifically says that the first incident was in the bathroom. Then he says, and in bed too. And then he proceeds to state that it was the victim, while he was laying in bed with the victim, it was the victim who touched him. So, Your Honors, it's clear that these calls, as Judge Morris pointed out, clearly establish consciousness
I didn't
of
actually
guilt.
point that out. Say about these calls, that was not in any way a conclusion.
I misspoke. I misspoke. You highlighted the case law, Judge Morris, and I appreciate that. These statements are not that of a person who innocently touched his 8 or 9-year-old niece during bath time. They clearly constitute admissions and consciousness of guilt. And in the Florida Supreme Court case, Penalver versus State, the court emphasized that conflicting theories on the meaning to be attached to the evidence goes to its weight and not its admissibility. I'd also point out that the state never changed its theory for admission of these cases, for admission of these calls. The state was consistent. The state consistently said during closing, the state argued, this is what we call consciousness of guilt, gentlemen. During the JOA hearing, after the verdict, the state was consistent.
But it also can be just as easily argued that it's Williams' rule.
The state disagrees that it's just as easily
Well, I
could be.
would expect you to agree with me, but nevertheless,
Well,
it's different incidents than the ones that were tried.
Well, the reason that the state disagrees is because the victim stated that this happened in the bedroom. And Judge Morris, you actually noted this, not pointed it out, but you noted that the issue here is whether the victim's vagina was touched. It doesn't necessarily matter where it happened in the house, whether it was in the bathroom or in the bedroom. The question here is, was this victim's vagina digitally penetrated by Mr. Martin?
Well,
And he admits.
Actually, it does make a difference where it happened, based on the allegations of the information, that, there are specific incidents alleged. And if the conversation and the phone calls don't match up with that, it is uncharged criminal behavior, right? So that is Williams' rule.
The information alleges that Mr. Martin digitally penetrated the victim. It doesn't specify
On a specific time frame, specific place.
at Mr. Martin's home. Where it happened in Mr. Martin's home, Mr. Martin suggested it happened in the bathroom. The victim testified that it happened in the bedroom. And that discrepancy was resolved by the jury. That was a question of fact that was resolved by this jury, where it happened within his house. So that testimony is consistent and matches up with the information. The victim testified he inserted his pointer finger in my vagina. She was very consistent with that. Mr. Martin argues, no, he innocently touched her, but then goes on to repeatedly ask for forgiveness and express consciousness of guilt and say that what he did was wrong. So it's the state's position that the trial court did not abuse its discretion when admitting these calls, and the state would respectfully ask this court to affirm the court's ruling with respect to the calls. And turning to the verdict form, in count 5, as your honors know, Mr. Martin was charged with capital sexual battery by digital penetration. And to sustain that conviction, the defendant's finger or fingers must penetrate and not merely have union with the relevant body part. Now, the state acknowledges that digital penetration is required, and the verdict form erroneously included union with language. But this error was harmless because the jury was properly instructed of the correct elements involving digital penetration in open court, and the instruction forms themselves contain the proper elements and the correct elements for this crime. They merely provided a definition for union at the end. But the body of the instructions specifically said penetration. It did not have union with language like the verdict form. So I just want to clarify that for the court.
So if there's a proper instruction, we should assume the jury disregarded the language on the verdict form?
Well, Your Honor, based on the case law, where you have a situation where the jury was properly instructed and the state presented no evidence of union with for this count, and specifically the victim testified that he touched her inside of her vagina. And again, during closing arguments, the state specifically stated, the next incident she described for you was that Mr. Martin, on a different occasion, put his finger inside of her vagina. So the jury was properly instructed. They received proper written instructions. And the state-
The instructions the judge read went back to the jury room.
Correct.
And obviously, if someone was a student that compared the verdict form and the instructions, they might have found a difference, but they didn't come back with a question.
No, they did not, Your Honor. There was no questions during deliberations. So it's the state's position that the error on the verdict form was harmless and does not rise to the level of fundamental
So the
error.
argument that it's fundamental error is wiped out by the fact that jury instructions said otherwise. Is that true?
Well, the state acknowledges that there was an error on the verdict form.
Yeah, but they didn't preserve it, so it had to be fundamental error.
Correct.
On that.
This,
And you're saying it doesn't matter because they didn't object and the instructions were correct.
correct, Your Honor. This issue with the verdict form did not come to light until the post-verdict hearing on the motion for judgment of acquittal and new trial. And it was actually the trial court that recognized that there was an error on the verdict form, and the state clarified that the jury was properly instructed and received proper written instructions with respect to count 5.
Smith, you didn't mention whether you want to reserve rebuttal on your cross appeal.
I do, Your Honor.
Okay, so you're down to 5 minutes.
Okay, so I'll reserve the rest of my time.
Please, you don't have to stop now.
Okay, I'll reserve my time. Thank you.
Right.
Okay, there's a bit to get through. So I want to point out just a few quick issues with what was discussed. I believe that the state is focusing on the word in or inside, but not on the word vagina. And the word vagina to a minor child, and this court has found this over and over again in case law, in its opinions, that is not enough. The description, the clarification needs to be what vagina means to her. Right? Vagina can mean labia. It can mean vulva. It can mean even just the area around. It can be up at the top near the pelvis. We just don't know. And as far as the in and into, your honors should look at page 239 of the transcript, because at one point the minor child said that she put her mouth into his penis. And so in and into throughout the transcript have been transposed by this minor child. And so to try to say that that's enough just isn't in the record here. It does not establish penetration at all. Case law is clear on that. And we cannot send a man to life in prison for something so faulty. And then as far as the calls are concerned, the court thought that they were not outside of the charges because of reliance on the state's argument at the motion of limine, not after she heard the testimony and saw everything that happened in court and saw every piece of evidence. Once she did, this court realized these calls should not have come in. They do not pertain to the crime, and they should not come in should this court remand it for either a new trial or a hearing on the new trial. And then the incident that's in bed, she touched his penis, he told her to stop. That is not the incident. And, you know, if we want to start saying, well, we should ignore bed versus bath, then we're going to have to ignore in versus on versus inside versus vaginal versus vulva. It's just creates just so much uncertainty. We have to be precise. We have to be precise when we're putting a man in prison for life. And here there's not precision, and it's not enough. So the, excuse me, my site is low. He never said he innocently touched her, by the way, at all. So that is important to notice in those calls because the state did contend that he was trying to say it was innocent. He did agree that he touched her when he was drying her off in the bath. He shouldn't have done it. And then one time in bed, she tried to touch him and he put a stop to it. That's all he testified to. That's all he admitted to. That's been the party line forever. And you'll see in the transcript as the minor child's testimony changes, it even changed a day before trial, and that's admitted in the record in the emails between the state and defense counsel. Her testimony changed so much that the court actually had to proffer with her, to ask her off the record, or excuse me, outside of the presence of the jury. And then as far as the verdict form, I do have to point out also the jury was not properly instructed in open court, and the state relies heavily on this. In fact, I think that's pretty much the majority of their argument on this form. But on page 531, the court actually reads out the incorrect jury form. It says in or union with for count 5. That's specifically on transcript 531. And then 584, the court reminds the jury that there's no other instructions, there's no other definitions. And so that would necessarily include the definition of in union with that's also on the jury instruction, written on the jury instruction. So if this court has no other questions, we would like for the court to affirm. And if this court does not agree with me that we should affirm, then we would like you to remand for a new trial with instruction to keep out the controlled calls and to, of course, fix the verdict and jury forms. If there are no other questions, thank you.
Your Honor, I'm going to go back again with respect to the trial court's granting the JOA after the jury's verdict, and just again point to the victim's consistent testimony. This is a child that at the time of trial is 12 years old. Her language was very specific. She said, in my vagina, inside of my vagina, and she specified that Mr. Martin used his pointer finger. There really is no question that digital penetration was established by the state in this case. It's very clear from the victim's testimony. With respect to the controlled calls, again, Your Honor, these calls were 4 days before Mr. Martin's arrest. He made these admissions during the call. He initiated this call and called her back. During the motion in limine, there were no additional arguments with respect to the calls, but if you look at the motion in limine, the written motion itself, he suggested that he innocently touched the victim's vagina. And if that were the case, you wouldn't have this second call where he's repeatedly asking for forgiveness and stating that what I did was really wrong and I have to pay for that. So it's clear that the trial court did not abuse its discretion in admitting these calls. With respect to the verdict form, on page 521 of the trial transcript, the trial court is reading the jury instructions to the jury, and specifically says, and count 5, to prove the crime of sexual battery upon a person less than 12, the state must prove the following 3 elements beyond a reasonable doubt. Mr. Rodriguez Martin committed an act upon the victim in which the fingers of Mr. Rodriguez penetrated the vagina of the victim. At the time of the offense, she was less than 12 years of age, and at the time of the offense, he was 18 years or older. The jury was indeed properly instructed. Now, the state acknowledges that the trial court went on to read the incorrect verdict form, but the jury was properly instructed, and the written jury instruction form, which the jury took back with them, contained the proper 3 elements to convict Mr. Martin of sexual battery by digital penetration. So it's the state's position that the control calls should be affirmed. The trial court's ruling on the control call should be affirmed. The error on the verdict form was harmless because the state presented no evidence of union with language, and the jury was properly instructed verbally, as well as the written jury instructions. And with respect to the cross issue, it's very clear that the victim's testimony presented alone, the victim's testimony alone presented competent substantial evidence to support the jury's verdict. So the state would request that this court reverse the trial court's order granting the motion for judgment of acquittal and remand with instructions to reinstate the jury's verdict, enter judgment, and sentence Mr. Martin in accordance with the jury's verdict. Thank you.
Thank you, Ms. Smith. Very much.
To our next case.
Handler versus Dave Russ, same day.